Good afternoon, and thank you for joining us today. This is the first panel in our two-part Rightsizing the Juvenile Court Lunch webinar series. Today we'll be discussing the case for establishing a minimum age for the juvenile court jurisdiction in Indiana. I am Liesl Pettis, a senior fellow with the Criminal Justice and Civil Liberties Department at the R Street Institute. R Street is a nonpartisan think tank promoting free markets and limited effective government. Prior to my role with R Street, I previously served as a prosecutor, a city councilor, and an executive director for Victim Services Organization and Child Advocacy Center. I'm honored to facilitate this discussion today. First, some housekeeping. We'll be doing a question and answer with our panelists for approximately 50 minutes today, followed by questions from attendees. If you have a question, if you could please drop that into the Q&A box, and I'll read those to the panelists at the end. If you have any issues with hearing us or video issues, please feel free to throw that in the chat box so that we're aware of it. I want to make sure that everybody knows too that we are trying to get through a lot of information today, and so we will be kind of keeping it to a tight timeline, and I may have to cut off attendees at time to make sure we get through all the questions. But if you have follow-up questions, again, feel free to put those in the Q&A so we can get back to them at the end. This panel is also being recorded, just so you know that, in case you are asking questions, but also we will be able to send it out after we finish today. Indiana has made several key adjustments over the last century to shape the justice system for children. Some of these efforts include separating children from adult jails in 1903, setting a minimum age for cases to be waived into the adult criminal court in 1978, and setting a minimum age for capital punishment in 1987. With more science, technology, and research made available over the last 15 years, efforts in Indiana have increased to make sure justice responses match the unique needs of children. These efforts have included an alternative sentencing statute for juveniles in 2013, raising the minimum age for children eligible to be waived to adult court from 10 to 12 years old in 2015, developing a juvenile competency statute in 2021, and prohibiting placing children under 12 in secure detention this year. It is clear Indiana has made incredible strides to improve systems for children when science and research backed appropriate changes. Today, we're going to discuss why a minimum age for the prosecution of children is needed to align with current research on brain development, increase positive outcomes for children acting out, and ultimately support public safety. For the panelists today, we've invited individuals with different backgrounds and areas of expertise so that we can answer questions from different perspectives. These are three very accomplished individuals, as you'll see from their long bios, and they're prepared for all your tough and insightful questions. So for our panelists today, we have Lindsay Grossnickel. Lindsay is a prosecutor for the Whitley County Prosecutor's Office. She started her legal career after being admitted to the Indiana Bar in 2000. She's also admitted to practice before the U.S. District Court, Northern and Southern Districts of Indiana. Lindsay obtained her bachelor's degree at Alma College and her law degree at Valparaiso University. After law school, Lindsay was a law clerk to the Honorable Patricia A. Riley in the Indiana Court of Appeals. She then went on to work as an associate attorney and partner at Bloom Gates and White Leather in Columbia City. She also worked as a city attorney for Columbia City. Lindsay then transitioned to the role of deputy prosecutor for Whitley County, where she specialized in juvenile court, veterans court, and child sex crimes. Lindsay has served as the Juvenile Detention Alternatives Initiative Co-Coordinator for Whitley County and Cosco County. Lindsay is the Vice President of the Whitley County Bar Association, board member, Secretary of Troy Alternative School, a member of the Indiana Prosecutor Attorneys Council Subcommittee for Child Support, an advisory board member of the Whitley County Corrections Advisory Board, a member of the Children's Policy and Law Initiative Indiana Subcommittee, Decriminalization of Youth Work Group, a member of the Youth Services Bureau Safe Place Advisory Board, and a member of the Youth Justice Oversight Committee Screening and Assessment Work Group. Josh Robner manages a portfolio of juvenile justice issues for the Sentencing Project, including juvenile sentenced to life without parole, the transfer of juveniles into the adult criminal justice system, and racial and ethnic disparities in juvenile justice. His work has supported reforms in numerous states through research and testimony. He's the author of several papers and fact sheets for the Sentencing Project, including How Tough on Crime Became Tough on Kids, Prosecuting Teenage Drug Charges in Adult Courts and Racial Disparities in Youth Commitments and Arrests, and he has had opinion pieces published in The Atlantic, The Washington Post, The Houston Chronicle, and The Hartford Courant. An expert in child and adolescent well-being, Josh has worked on juvenile development issues such as access to primary mental health care, tobacco prevention, and comprehensive health education. Josh previously worked at the School-Based Health Alliance, Metro Teen AIDS, the Campaign for Tobacco-Free Kids, and the Council of the District of Columbia. He received his undergraduate degree from the University of Rochester and a Master's of Public Policy from the George Washington University. Our third panelist, Dr. Jennifer Woolard, is a professor of psychology and adjunct professor of law at Georgetown University. She began her career at the National Victims Resource Center. While obtaining her doctoral degree in development and community psychology at the University of Virginia, she also served as a victim witness volunteer in the County Police Department, a staff member to the Virginia Commission on Family Violence Prevention, and a consultant with Virginians Against Domestic Violence. She then joined the MacArthur Foundation Research Network on Adolescent Development and Juvenile Justice and became an assistant professor at the University of Florida Center for Studies in Criminology and Law. In 2002, she joined the psychology faculty at Georgetown University. Her research and action laboratory, the Georgetown Community Research Group, studies individual and family experiences with systems of care and control in order to create fair, effective, and just legal processes. Projects examine how youth and parents understand the right to remain silent, the right to an attorney, and the right to a trial. Her lab is the evaluation partner for the Youth in Custody Practice Model Initiative, which helps juvenile correctional institutions implement evidence-informed and developmentally appropriate practices. Dr. Woolard has testified as an expert before federal and state legislatures as well as criminal cases. She has presented her research findings to a wide variety of academic, legal, and policy audiences and won several awards for teaching excellence, including the Dean's Award for Teaching Excellence. She currently serves as the chair of the psychology department. So three extremely accomplished individuals to answer all of the questions today. So what I'd like first to do is just start off with kind of painting this picture of what does it actually look for a child under the age of 12 to be in the juvenile justice system. Lindsay, if you would start.
Thank you, and thank you for having me today. And I'm sort of in awe of the other two panelists and everything they've accomplished. So I really am thankful to be here. So what does it look like for a child under 12? It can look like so many things, and that's kind of the difficulty of it. I've had just the smallest child come into our courtroom holding a stuffed minion, having been accused of some serious crimes. And I look at this little kid in opposition to the crime being charged, and it's hard to grasp what we're doing in the courtroom. So I start with that picture to say that that's not much of what I do, because I do frankly try to stay away from having youth under 12 prosecuted. As far as in Whitley County, if I see a youth under the age of 12, I start asking a lot of questions. So one thing to consider is that the Department of Correction, where you can send girls or boys if they admit to certain crimes, that's a possibility, but not for youth under 12. So that's not a possibility for me as a prosecutor. So what it looks like is runaways. It looks like truancies, not attending school. It looks like incorrigibility, so behavior issues. That's what much of those look like. And when I get sent those cases, those cases are ones that I oftentimes will send back with questions about what sort of, do we have any known mental health disorders? Do we have any known DCS involvement? What other factors are there? Because if we have a child who's running away, I see a lot of in-home issues are really the vast majority of the kids that I see. So if we're having strictly in-home issues, then I need more information before I'm going to just file a runaway charge. Because if I have an 8, 9, 10-year-old kid who continues to run away, that's what's called a status offense. So it's not a misdemeanor, it's not a felony, it is specific to a child that they need to stay home because they're not listening to what their parents are telling them to do. And then I have to consider, what can I do through my authority with the prosecutor's office, get that kid to stay home? And frankly, not a lot. Being put on probation does not tell the kid to stay home. They can meet with a probation officer. Probation officers drug test people, which is something that I'm not really going to be super worried about with an 8 or 9-year-old, especially if what they're doing is running away. So that really is the vast majority of my cases. I have from time to time had the little minion boy that I described. He opened an umbrella in the front seat of his mother's car, and he, by all accounts, did so to harm her and to harm himself. And that was brought in before I really kind of shifted some perspective on how I treated these cases. This little boy had some serious mental health issues, and once those were treated and adjusted, he started doing great. He was acting out seriously and violently for some time. And what I know is that he needed that treatment. And what I sort of came to gather down the road is that that wasn't something that needed to be done through the prosecutor's office for him to get that treatment. He needed the treatment regardless. And so for me to intervene, he was already being treated. His meds needed to be adjusted. So he was already in counseling. He was already receiving services. So, and just briefly, what it looks like for a youth that could be potentially securely detained if they are potentially violent, that looks like jail. And I've been to these places. It truly looks like jail. For the first 48 hours, they are in a cell with the lights on, nonstop. They only get to leave for meals and parents, attorneys. And if they speak to a parent, if they speak to an attorney, they are handcuffed and they are chained to a bench. And that's just for all of them. That's what that looks like in a secure detention facility. And so the psychological impact it had on me when I went to visit was kind of serious. And I told myself that I was probably going to be very, very careful who I ever sent there again, because it was a little bit more free. Before, I would say I started in 2006 working with the kids, and the first couple of years I kind of just went along with the flow, and until I started really kind of researching these issues and looking into it. And I have not ever sent a child under the age of 12 back to secure detention facilities since then. Because when I went and I looked, it impacted me.
That was really helpful to get that really first-hand experience from you, Lindsay, and paint that picture of what you're seeing in Indiana. I'd like to go to Josh next to talk a little bit more on a macro level, but I know you also have some ideas of what's happening at an individual level. So what are your thoughts of what that actually looks for somebody under the age of 12 to be in the system?
You know, I think it's interesting to hear the stories from Lindsay about the kinds of kids who come in. The data back that up for Indiana. Council of State Governments did some work last year for the state and found that 1/3 of the cases of kids 12 and under in juvenile court are there for the kinds of status offenses that you heard. Another half are there for misdemeanor charges, which of course leaves only about 1/6 of them that are felony charges. That lines up pretty well with what we see on a nationwide level. We have about 700,000 kids who are sent to juvenile court on delinquency charges. Those are things that are, crimes if they're committed by adults. But a very small sliver of those cases involve kids 12 and under. It's only about 3.5%. This is a very small piece of what juvenile justice looks like in this country. The courts are really equipped to deal with 16-year-olds and 17-year-olds and 15-year-olds. So let me give you a sense of this. I said 700,000 kids in juvenile court on delinquency charges. 25,000 of them are kids 12 and under. This is not the thrust of what juvenile courts do. It's not what they're equipped to do. It's not who juvenile probation officers and juvenile court staff are equipped to deal with, which is one of the reasons this fails so much. What kind of charges are they there for? Overwhelmingly not drug charges, which is not the case for other ages. So when you look at specific charges, simple assault is very common. Which most of us would call getting into a fight when, a couple of 5th graders are shoving each other. It's not hard to call that simple assault. things that you yourself might have done when you were 12 years old and weren't in your right mind, of some shoplifting or ticking off an adult. And the ticking off an adult when it's a police officer can be disorderly conduct or contempt of court in other settings. Now, this generally is not a story about incarceration. On a typical day in this country, we're talking about fewer than 600 kids, 12 and under, who are locked up. But the reasons that they get locked up are the same sort of low-level things that I mentioned before: the simple assault, disorderly conduct, and contempt of court. Violations of probation is a big one also. So once kids are in the system for having done the kind of low-level things that kids generally do when they get arrested and then fail the terms of their probation, that opens the door to incarceration later on in many cases. But it is worth noting, you know, and I think Lindsay had mentioned some serious cases. It can be sexual assault. I think that Professor Woolard and others can speak more expertly about this than I can. But I think that what's important to realize is that these are often learned behaviors that kids have. You know, there's no sort of clear line between a victim and a perpetrator. In these cases, the kids who are there for the more serious cases are typically victims themselves. And I think that's also true on any sort of violent offenses also. These are kids who are often living in very violent communities, surrounded by violence themselves, and so it's not surprising that they would act out. Now, whether the courts are capable of dealing with that or whether there are providers outside of the court system, that's what we're here to discuss. Knowing that court involvement, and I'll get into the research later on, is detrimental in so many ways. The question is, what's the better alternative? How are we going to help these kids? And I think that that's where the research is really helpful to us.
Thank you for that. Professor, I'd like to go to you next to not only answer kind of what is that question of what does this look like for children under the age of 12 to be in the system, but then start to get into that next piece that Josh was starting to touch on, which is why do we need to change the system and why is now the time to change it?
Sure, thanks so much. And let me say thank you for the invitation to be on the panel. I very much appreciate that and appreciate the folks who are watching with us. I think, you know, Lindsay's spoken to the direct experience in the system and Josh has given us the overview. Let me just remind us of what kind of kid we're talking about when we talk about 10, 11, and 12, right? We're talking about kids who have barely started puberty, if they have, right? And are really just at the, not even in adolescence yet, right? But at the, right in the midst of childhood. So we'll probably talk a little bit more about this later, but they're really in this active time of development. Their capacities in all sorts of ways, right, lead us to believe that they are not even capable of exercising the kind of judgment, foresight, consideration, and so forth that we might see in older teens and young adults. In terms of why we need to change the system and why now the time to change it, I mean, apart from, I'll speak from the research side of things, is that over the past 20 to 30 years, you know, we've been able to engage in increasingly sophisticated studies of child and adolescent brain development as well as behavior development. And so much of what we've learned over the past 100 years has been confirmed and strengthened by the advanced technologies that we have, such as fMRI and so forth, that allow us really to see the differences in how children's brains are activated and acting under certain tasks compared to older adolescents and young adults, much less full adults. So I think we've got a much better understanding of where young people are in their development. And we also have a better understanding of what the impact of early engagement with the justice system and how that can end up impacting both the shorter term and the longer term prospects for these young people.
Thank you. Lindsay, I'd like to go to you next. And with that same idea of why do we need to change the system and why is now the time to change it? And one thing I do want you to hit on is you talked a little bit about the prosecutor you were when you started and the prosecutor you are now. And I think people would be interested to know why you also made that change to where you are today.
Well, I'm also the Juvenile Detention Alternatives Initiative, JDAI coordinator for my county. And that started several years ago. And that made a lot of impact to just start looking at why we do things the way we do. So we get grant funding to be a JDA county. And so I coordinate those funds, but it really forced me to look at what are we doing? And so when it's why is it now? I mean, I suppose why not? We're talking about kids and we always want to do it better. So it's really popular right now in the state of Indiana to have problem-solving courts. And problem-solving courts in the adult context, they treat the person, not the crime. And if you treat the person, you are doing that full wraparound to hope that they don't continue to commit crimes. So drug courts are very popular. I do this Veterans Treatment Court, and it's services and help. So when we look at that on the kid level, we want to treat the kid, and I prosecute crimes. That's my job, and it's my job whether I'm doing it with adults or if I'm doing it with kids. So is there a better place to serve these kids? Because I am limited in what I can do. I cannot order families to do other things than to get kids back and forth to appointments, to help in costs, things like that. I cannot make a parent do family counseling. I cannot make parents do certain things. And when we're talking about kids, it's just over this period of time, and Whitley County is a small county, which is nice. So I know every single one of these kids, and, I know when they don't have hot water. I know when, mom or dad's been incarcerated. I know all of these things. And so many of these things it's just one on top of another, and it starts to break these kids down, and I see it. And what I don't want to do is add to it. And I can see, and I have seen that I've added to it in the past, and I think that I would certainly do some things differently if I could go back and change it. But what I want to do now is say, where can I get the treatment for this kid? Where can I get some results that's going to help the whole, not just the child? Because I can help the child all I want, but if I don't change anything in that home, I'm sending that child back to the exact same circumstance, and it's not helpful. And then I'm going to see that kid over and over. So getting that help on the front end is really important. And I went to a seminar recently, and I had a prosecutor tell me, I am not a social worker, and neither am I. and she said it kind of in a way that was more so, I've got to make these kids answer for these charges, which is absolutely true. But when we look at these very young children, I think they might need more of that social worker, not someone who is prosecuting them for their crimes, regardless if the system's built for rehabilitation. That's not how it starts.
Thank you for that. Josh, from your perspective, why would you say that the system needs to change, and why is the time now? And you're on mute right now. You're still on mute. There you go.
Okay, great. Thank you. If we only had some 16-year-olds that'd be able to work the technology better than I can. So, I think that what's important to realize here is this isn't like my opinion about what's better for kids. This is what the research backs up. And I think this is especially true for the young kids that we're talking about here. The system involvement is itself quite traumatizing. When you picture a 10-year-old in handcuffs or in the back of a police car, you can imagine how terrifying that is for people our age who are listening to this, and for 16-year-olds. For 10-year-olds, it's just beyond traumatizing, and it changes the way that they look at themselves and changes the way that the community looks at them. There's a whole set of research about labeling, and that's not only about how the community sees a kid as being a bad kid now, but the kid sees themselves as being a bad kid. Over my shoulder here, those are photos of my own kids. And the thing that we all want for our own kids, and mine are 13 and 15 now, is have the right peer group, right? Like, you want them to be surrounded both by caring adults and by kids who are good influences in their lives. And by diving them deeper into the system, you've really changed what their peer group is. This network of kids, if you're talking about detention or commitment, that is not who you want them spending their time with. So what are the consequences for court involvement? It's really quite clear. Educational outcomes are much worse. Kids are way less likely to graduate. And we're talking about kids who are like justice involved before middle school here is an age that we're talking about. But the research will echo that throughout their adolescent years. Poor health outcomes, meaning even lesser life expectancy. Looking at kids who are justice involved and not justice involved in the same community, kids who are justice involved are 50% more likely to die prematurely than those who are not. I mentioned the trauma of processing, but here's something that I think the legislature ought to be especially concerned about, and others. All of us are concerned about public safety, and this is unapologetically a public safety agenda, because kids who are arrested are more likely to be arrested again, and they're more likely to be arrested on more serious charges. So we often talk about what's best for the kids or best for their family. And it doesn't take much of spinning that Rubik's Cube a little bit to realize when we talk about less likelihood of reoffending, we're talking about less crime. This will make us more safe. This will make you more safe in Indiana to have fewer kids involved in the system and to connect them with the services that they really need.
Thanks, Josh. So I know a lot of people have said if the courts are not the appropriate one to intervene, then who is? Because clearly these kids need help. And so, Lindsay, you started talking a little bit about social workers. And so I'd love for you to expand more on if it's not the courts intervening, then who should be doing it, and what does that look like?
So, I mean, we have a mental health problem in this country. We have it in this state. We have it in the county where I live. Just as an example, my daughter has been experiencing some anxiety. She's 11. I wanted to get her into counseling, and calling around, I was told it was going to be 3 or 4 months to get her into almost anywhere. And she's super well adjusted. I mean, she's having some anxiety. If she were in crisis, I don't even know what I would do. So take that into this context. And there is a mechanism, and it's through the DCS, and there is something called, so it's just under the statute. And so Chin 6 is how it's referred to, and it's because it's section 6 of the statute. But it is for, and it's geared towards youth with mental health issues. So that is something that the DCS, and so, you know, we're talking about the Department of Child Services, DCS. CHINS is Child in Need of Services. I mean, it actually sounds like something that we would maybe want to use, but there's a huge stigma on it. And when parents have DCS cases filed, what it looks like is they're abusing and neglecting their children. Sometimes it is just an inability to be able to give them the care that they need, doing it alone. And so, and they have, and I do want to mention, the same pot of money that we have through the prosecutor's office. And in fact, it is the DCS's money. So when the DCS, you know, if we want to send a child to residential services, we want to take them out of their home and put them somewhere that's not secure detention, that's not the DOC, that is DCS money. They have to tell us it's okay to send that child. They have to approve it. So it's the same pot of money. It's just sometimes it feels like, well, no, it's your problem. No, it's your problem. And that's not good for kids, and it's not good for families when we're trying to say, no, it's you, no, it's you. We really should be looking at what the issue is and how to serve that child. Because like I said before, I can't help the family. The DCS can actually require the family to do certain things, and not because they're neglecting their child. Maybe it's an inability, maybe they don't understand how to. And because that younger age, that is much of what I see in these younger kids. It's not, you know, some kid who was born terrible and is just a terrible kid, and I know it, and I need to send them somewhere, because I can't send them to the DOC. I can send them to secure detention, and the DCS cannot. The DCS cannot securely detain children. And that's about the only thing, and that's about the only difference. So we need better mental health services. We need better counseling in schools. We need better access. So, you know, if we're going to funnel money somewhere, if we want to really push something that's going to make a positive impact, is getting more access in schools, getting more availability within communities. Indianapolis is a big town. They probably have a lot of counselors. I bet they have the exact same problem that I was having trying to get my daughter into counseling. It's going to be a wait list everywhere because we just have a desert of services.
Professor, what do you think about that? What's the more child appropriate intervention? What interventions do you think are going to be more successful than the court intervention?
Right. Well, I would echo what Lindsay's saying. When we talk about taking a developmental approach to understanding kids, we're talking about kids in their environments, and their environments are their families and their neighborhoods and their schools and so forth. And so some of the most effective responses to children who are in need to take into account those contexts in which they are living, right? And the kinds of supports and resources that their families and their neighborhoods may or may not have access to in order to support those children. So I would certainly agree, if I was in charge of investing funding, we really be thinking about a prevention approach, right? Or an early intervention approach, and one that focuses on identifying need and trying to support and respond to those needs. The mental health services crisis, as you were describing, Lindsay, I think is certainly the case. And certainly the need for crisis intervention services is always there. But these prevention and early intervention services are exactly the kinds of things that these young kids are going to be able to respond to, right? These are times when we can shift trajectories. Kids are incredibly malleable at this age, right? So it offers the opportunity for effective intervention. And I want to say there are empirically based, research-based, and validated interventions that are accessible and possible for even young kids, and even young kids who may be engaging in pretty significantly serious behaviors that we know can work well and can work better, as Josh was saying, than the kinds of outcomes that we see from an early engagement with the justice system, however well-intentioned that may be. Just the function of engagement itself is going to have negative outcomes going forward.
Josh, I know you've worked in several different states across the nation on this kind of stuff. So what is your thoughts about what's a better intervention versus the juvenile justice system?
Well, one of the things that I was thinking as I was listening to my colleagues here is that very quickly we dive into like the most serious and difficult cases in here. But the data really don't back up the idea that that's most of the reasons that kids get court involved. I think I said earlier, data from the Council of State Governments, a third of the cases in Indiana juvenile courts for kids under 12 and under, were status offenses, and half of them were misdemeanors. These are normal behaviors that you can expect the kids are probably going to age out of or only do once. I speak from experience from the pack of Topps baseball cards that I stole in 1985 and didn't steal anything ever again, because that's the kind of thing a 10-year-old does when he thinks he can get away with it and the shopkeeper is filling up his slushie. Like, that's my story. And I think that most of you, if you think back at your own like 10, 11, 12-year self, that's the kind of thing that you did. So recognizing that most of these behaviors are pretty normal and don't warrant the involvement of the state and certainly not the court system. A couple of kids who get into a fight at school, like when I was at school, an assistant principal would deal with that, right? Like you got some after school detention, or you clapped out the erasers, or you begrudgingly shook hands with the kid that you got into a fight with. And then you got over it because, you're 10 years old and you have the attention span of a fruit fly. Your life moves on from there. So I think it's important to realize that most of the time we're talking about low-level stuff. Thankfully, let's not lose sight of that. We are not talking about axe murderers here. We're talking about shoplifters and kids getting into fights. Now, there's been a good movement on this around the country, and I think that was the question you wanted me to answer, because a few states have, in fact, raised their minimum age in the way that we're talking about here. New Hampshire and Maryland have a minimum age of 13, age of 12 in California, Massachusetts, Utah, Delaware, and New York, and Nebraska has an age of 11. Now, about half of the states have no age whatsoever, which is the case in Indiana now. And there's a few states, it's pretty common, you know, they wrote their juvenile code sometime around 1903 and said, I don't know, age 6, and they haven't touched it ever since. There's this George Carlin quote that I absolutely love, that he says, anybody driving slower than you is an idiot, and anyone driving faster than you is a maniac. Like, I think we recognize this as we push forward for reforms. This isn't something that a lot of states have actually talked about, which is why I have a pretty narrow list of states. But any of them that did, age 13, age 12 is absolutely the place that states are moving in this. No one has gone from not having a minimum age to court involvement to putting one at age of 6 or raising it from 6 to 8. I think Indiana has a chance to join what is happening in a lot of other states, and I think that you will see it in many other places too. And I'm really excited at this opportunity. It's a common sense reform, and I think it's something that the system is capable of taking on.
Josh, you teed up the next question nicely, so I'm going to put it right back at you, which is why 12? Why is it not 8? Why is it not 16? Why are we picking 12?
You know, so it's interesting because, you know, and I don't think this wins me all that much love with state legislatures, but the UN Convention on the Rights of the Child says age 14. And that's something that you see in much of Western Europe and other countries around the world that we generally compare ourselves to. This proposal is age 12. That aligns with what the American Academy of Pediatrics supports. It's what the Society of Adolescent Health and Medicine support. We've seen the American Bar Association come out with statements that aren't quite endorsing, but are, you know, this close to endorsing. You know, this is where the field is moving on this. And I think age 12 makes sense as a place to have this discussion. In Indiana's case, that was a discussion about detention, understanding that kids who are that age are different than kids who are older than that. And court involvement itself is the next place to go on this.
Professor, what do you think about that? Why the age 12? What do we know about science that would support that as well?
Right. So the legal line drawing is a little bit outside the parameters of developmental psychology, but let me tell you why I think you're in the right spot as you're thinking about that. So I was mentioning before the advances that we have in the ability to examine the physical and the functional development in the brain. And what we see is that, you know, brain development as we start moving into 11 and 12 and 13, and as Josh was mentioning, 14, is not so much about growth as it is about reorganization, right? So the neural networks are reorganizing during this adolescent time period, just kind of like kids' social networks reorganize as they're from elementary school to middle school and so forth. So some of the key parts of the brain that we really think about when we think about holding someone responsible, when we think about trying to change their thought patterns and their actions, right? That's what's beginning to be in play and moving towards maturation and into this time. So the prefrontal cortex, right? The CEO of the brain that's responsible for self-regulation, that's responsible for being able to think into the future, to say, if this happens, then this happens, then this happens, right? If I open the umbrella, then this is going to happen and so forth. We know that that's just gearing up, if it has started gearing up around ages 11, 12, 13, right, 14, and won't be moving into its full-on development and reorganization until we're hitting to mid to late adolescence and continuing into early adulthood. Right. But at the same time, the part of the brain that's socio-emotional, right, that gets us riled up and impulsive and sensation seeking, that is also starting to begin to mature and to kick in around 12 and 13 and so forth. So while I can't tell you like 12.5 or 11.6 or whatever that is the right age, this is really a good place in the sense that kids are not fully developed, and actually the big action that's happening in adolescence hasn't even really kicked in. So it's a great opportunity, I think, for whole person intervention. And that is not focused so much on a justice system approach, but is focused on a care and early intervention approach.
And Lindsay, what are your thoughts from your kind of practical world experience in the courtroom? Why 12?
Yeah, so I mean, I believe in science, and I believe in the data that has been put out here today. And that's what we should rely on, frankly. So that's one piece of it. And also, I can tell you with a huge amount of certainty that prosecutors across this state are not typically filing against kids under the age of 12. They're for the most part elementary school kids, and it's not happening. I think that there's probably a consensus that that's not the right place for kids. So, but then there's that, that fear in the back of our mind. What if something really serious and terrible happens? So somehow we need to leave it open for that super serious issue that may arise. But for the most part, we're not filing in those cases. Prosecutors are not filing in a huge number under that age because we know it's not our place, because it's probably something that's going on in the home. It's probably something that's going on with the kid that maybe needs to be dealt with in a different way. So we don't file those cases. But we're scared. So we want to leave that door open. But also, just from a strictly legal standpoint, the ability to understand the process is part of what all people should have when they go to court. They should be able to understand what's happening to them. They should understand their rights. They should understand, if they're admitting to something, if they want to have a trial, what those things mean. And at that younger age, I don't believe that that's truly possible in many cases. And I'm going to go back to my daughter. I asked her, what do you think the right age is? And she's 11. And she said, like my age, like middle school. And I said, why? And she said, because I feel different now than I did when I was in elementary school. And you know what? She's super smart. And I believe she does, because her brain is like super speedy growing right now. And, and she's changing, and that, she's going to be more responsible. And that age, there's probably not a magic number, but it's certainly, I think there's certainly a time in which kids can start to comprehend things more and take responsibility for their actions. Otherwise, we're looking at the parent. Why did, some misbehavior? You see a kid acting out at the grocery store. Are you blaming the kid, or are you wondering what the parent did to not be able to wrangle that in? I mean, we look at that as prosecutors.
I just want to remind all the attendees, we are going to be going into our last question right now. So if you have questions for our panelists, please feel free to drop them into the Q&A. I do see one there already that we will ask at the end. But Lindsay, you started to ask one of the things that we again hear a lot. What happens if there's the worst case scenario? Something extremely tragic happens at the hands of somebody under the age of 12. And so let's actually pass it over to Josh. And I know this is probably one of the most challenging questions to answer. What happens in those scenarios if the court is not intervening?
Well, generally speaking, these are kids who have been through a really traumatic experience in their lives. That behavior is surely the residue of untreated traumas in their life. And so the question, when you look at a kid who has committed that sort of serious offense, is, do we really believe that the juvenile justice system is capable of offering that sort of treatment? And that's why we see this movement going away from a punishment mentality for younger kids in all the states that I mentioned. I mean, it's Nebraska and Utah most recently. Maryland passed it last year. Understanding that the juvenile justice system is really not equipped to provide that kind of meaningful support. I mean, if you think of a kid, who has committed a very serious offense, they are also going to be traumatized by that experience itself, and I think it's important to realize, all of these kids are coming home someday, right? Like, we have sharply limited the use of life without parole for people under the age of 18, much less under the age of 14. Limited life sentences. So, we need to be giving these kids tools to re-enter, to be part of a family, to support the family as a whole. And that's where the answers are going to be. The justice system, by removing a kid from their community, doesn't really give them tools to address the behaviors in a way that they'll be able to behave better when they come home, which again, they all will.
Thank you. Professor, what are your thoughts about that? What do we do in the most tragic cases?
Right. Well, thankfully, they're incredibly rare. I think as Josh was saying before, and we're really talking about the majority of kids are not here. But for those tragic cases, for the young children, the few young children who might be engaging in these quite serious kinds of violent offenses, right? I would agree with Josh that I think we need to think about what's our goal, right? We want that to stop. We want to protect public safety, right? We want to ensure that that's not going to happen again. And in my opinion, and I think some of the research backs this up, right? We need to look at the interventions that are going to be most effective in doing that. Interventions that are based on punishment or deterrence, things like that, we know simply do not work, right? They simply do not work. And so an intervention approach that is going to focus on the child and the child's family and the services that they may need to intervene, I believe that's going to be the most effective route to protecting both public safety and engaging these youth who, as Josh said, I would agree with, likely have many complications and challenges in their lives, some of them quite extreme, that need to be responded to in a holistic way and in a way that focuses on treatment and intervention rather than incapacitation.
Thank you. And Lindsay, I wanted to end with you on this question because I don't think that this is just always a concern for legislators, but I think prosecutors have had this question at times. In fact, I, as a prosecutor, had that question at times before I've kind of deep dive. So can you tell us, what are your thoughts about what happens in these more tragic cases?
So it is the hardest question because when I think about really young kids, my job is safety of community, safety of the kid, making sure that our community is safe. So in the vast majority, I'm not really worried about safety with most of these crimes. But if you're talking about some outlier that is the most horrible thing you can think of, some sort of murder or rape or something like that, you do have to think about safety and what happens if this kid remains in the home? What happens if there's not some intervention? Of course, there's going to be some intervention no matter what. So what is the proper intervention? I don't see in any way that where harm comes in if we look at competency. So if there were to be we need to make sure that there's, we can hold someone accountable for a terrible action. There could be a carve out in, the most, high level felonies, violent crimes. I mean, there's a definition of a serious violent crime. That could be looked at as some sort of carve out, and then looking at competency of the child. I mean, if we're talking about an 8-year-old who has killed his mother, I mean, I've got a lot of questions, and it doesn't start with, oh my God, this kid just killed his mother. He was born terrible. What happened in this kid's life where it got to that point? And, whether it was what he saw, what's happened to him, something like that. I keep using boys because I have a daughter and I'm never going to consider that could happen with my child. So with that in mind, I want to make sure that everyone's safe, and I want to make sure that that child's going to be able to process through the system in a way that is fair and just to that child, and also fair and just to any victim. And I think a competency evaluation is where you would start to find out, is that youth competent? And if not, then what, right? I mean, there are, then you start looking at, some sort of institution where we place a child, as an adult. If they're not competent, they're placed somewhere until they become competent. Can a child ever become competent, depending on the evaluation? And I think those questions would have to be answered before you move forward. And if they were deemed competent, then what do you do? As Josh said, they're coming home. I mean, we don't waive 10-year-olds, but we don't. So what do we do? And what, systems do we have in place? We still need a fix. We still need something that's happening on that front end, no matter what. because we can place them somewhere and they're going to come home, or, you know, they're going to go somewhere other than a secure facility, a correctional facility, and they're probably going to go to some sort of behavioral facility. You know, in that scenario, I'm having a hard time imagining any other outcome.
Thank you. I really appreciate two things. You kind of talked about the other tools that are available, already available. And when I was a prosecutor, we actually did have a minimum age set. And so those tools were already being used in the state that I was practicing. But I also like just looking at the reality of these 10-year-olds aren't going to be going to a lifetime in prison regardless. They're coming back into our communities. So what are we doing to make them safer? Thank you guys. I really appreciate all the answers you provided today. Very insightful. We did get one question from our attendees, and a reminder that if other attendees have questions, please feel free to drop them into the question and answer. So this question is there a way to exclude children below a certain age from formal prosecution in delinquency court, but maintain a limited form of jurisdiction connection so that diversionary services can still be offered and provided? Linda, I think you're probably going to be the best one to answer this because of your familiarity with Indiana law, but do you want to try and take a stab at that? And then Josh or Professor, if you guys want to add in, please let me know as well.
So, and the short answer is yes. And I think that probably happens in a lot of cases. I think the data would tell you, and I think Josh probably has some data on this as well, that a lot of cases that are filed against youth under the age of 12 do not go to disposition. So they get filed to kind of prove a point, to, we're going to tough talk a kid, we're going to teach them a lesson. And that's what a lot of it is. And so, there may be an informal resolution with, they're going to go and meet with a probation officer, and the probation officer is going to tell them that the parent needs to put them in some counseling, or if they shoplifted some class about that and why not to do those things. But so, yeah, I mean, any prosecutor can do an informal adjustment, and that's most likely what is happening largely now. And so the question is maybe going back as to why put it with the prosecutor's office, and where can it be addressed otherwise? So, if we're talking about kind of general misbehaviors, I mean, Josh said that he took some baseball cards when he was a kid. So are we really going to, put that kid in the system to get them to take a class to tell them not to steal? No. I mean, we should probably have their parents teaching them that, so those informal adjustments really are for very low level things. And that's really what we're talking about. I don't believe that prosecutors are super interested in addressing these really low level things at the level of filing charges and pursuing it, through that avenue. I think there are different avenues.
Josh or Professor, did you guys have anything to add in response to that question?
Yeah, I mean, diversion, it's really always an option, right? I mean, it's different in different states, but I mean, we call things by formal names that are also using common sense. So like, a couple of fourth graders getting into a fight in the hallway and then have to meet with the school principal. You could call that diversion. You could also call that just school discipline as a way of dealing with that. So yeah, those avenues are always going to be open as a way to work with kids to get their behaviors in a better place.
Yeah, I would say the same thing. And also to think about, for many of these very low level things, as we were saying, formal intervention is probably not even necessary, right? We know that most kids are going to do these things, and most kids are going to stop doing these things. So I think, as Josh was saying, if we call what would have been just the normal thing that happened back when I was that age, if we want to call that diversion, that can certainly be called diversion. But really, remembering that formal kinds of engagement has its own costs, right, and consequences, and balancing the need for intervention with what's likely going to not happen again or desist or being taken care of within the family or the school anyway, I think is an important consideration.
Great. Well, thank you all for your time today. I really appreciate you talking about what we're actually looking at when we're talking about these types of cases, both just how limited it is, as well as the types of cases that we're generally talking about, the tools that are already in place and that are actually more child appropriate for these kind of issues, and how that it really can increase public safety by using these new avenues. And I really loved hearing too, just how science and perceptions have changed over time to see how this is actually a better way to go because of what we know now. And I also want to just let attendees know that each of the panelists has agreed to share their contact information. So if you have follow-up questions from any of these panelists that you want to ask, we're going to put those up here in a second. And then of course, 3 questions came in as we have 4 minutes left. So let me try and get to a couple of these and go through them as quick as possible. We'll probably try and just have one person to answer. So if you really want to answer, please raise your hand. Is there a difference in treatment for children whose parents are offenders? And are they more likely to be put through the court system?
I think the data definitely backs up that kids whose parents are system involved are much more likely to be system involved themselves, which, you know, sort of gets to the failures of our criminal and juvenile justice systems to break those cycles. I mean, that's one of the big reasons we really talk about diverting kids away from the system because of that intergenerational impact.
I saw something familiar as a prosecutor. You unfortunately see more juveniles in the system whose parents are, but I don't think the treatment of them through the system is different. The tools are the same. What might law enforcement responses look like under a minimum age, i.e. they get called to respond to a child under the age? Lindsay, do you have a feel for that?
So it always feels more informal too. Law enforcement officers, I can tell you that a lot of times cases get filed with youth under 12 because an officer is at the house a lot. And so oftentimes we'll get a report based on frustration because they go out to the house because it's a push shove thing that's happening with mom or sibling, or, you know, the kid is acting out and a parent is sick of it. I had a kid not too long ago where the parents just drove him to the police station and made him tell the officer that he stole money from parents and was kind of generally acting out. And so law enforcement, unfortunately, is oftentimes used in that way as a, hey, will you fix my kid? And that's not their job, but they get frustrated when they have to go out and hear those cases. And then trust me, I hear it, probation hears it. And, you know, it's a failure in the system as to what else can we do. And an officer's not really the one who's equipped to kind of give that advice.
Lindsay, I want to cut you off just because the last question is a great one that I think we should answer, which is part of the issue that laws are not equal for all children across the state. And I think what they really mean is, are these cases being handled differently community to community? And do we need more of a statewide system to kind of say how we're going to handle them?
I'll answer quick. Yes, there's, you know, the justice by jurisdiction, I think you hear a lot of the time. And as I said, I don't think a lot of prosecutors file cases like this. And so, you know, why not make it uniform? Why not make it make sense? And let's all do it the same way.
I mean, there's uniformity all over the system. You actually started out with some great history in the state of Indiana of sort of setting some parameters of what the state of Indiana believes in and ought to do. This really fits in with that trend, historical, I don't know, trend is the word for it, the history of the state of Indiana, you know, to make sure that there is a level playing field. We really can't get away from, you know, the inequalities by geography and also by race and ethnicity. You know, we see misbehaviors treated much more harshly when it's youth of color than by white kids. There's just no doubt that that's one of the concerns that we have here, but we really need to be concerned about what's best for all of our kids, wherever they live, whatever their background, what the correct response is, and understanding their youth and immaturity.
I think that is a great place to end. We're 1 o'clock on the dot. I am going to put up the panelists' information in case you want to reach out. But thank you all for being on the panel, and thank you for everybody who's attended today. I hope it was very helpful.
Thanks so much.
Thank you.